Hello, everybody, and welcome to our webinar today entitled Writing High Quality Multiple Choice Questions for Law Professors, Finding Ideas, Framing Them, and Editing Them for Plausibility, hosted by Beth Donahue. My name is Carter. I'm an ExamSoft team member. I'm very excited to have Ms. Donahue host this webinar for us today, and we're sorry about that couple minutes of delay. We were having some technical issues, but now we're going to go ahead and get it started. Just some background information. Beth Donahue is a former editor and program director of the Multistate Bar Examination, as well as a former manager of a large technical team developing online assessment programs for K through 12 standardized tests. She is the co-founder of BarCrowd LLC, a company developing crowdsourced assessment software for use as a teaching and learning tool in law schools. If you have any specific questions, we encourage you all to type them through the questions feature on the right side of your screen in the GoToWebinar control panel. Right now we're showing you kind of where that is. So if you'll just locate that, then anytime you have any questions throughout the webinar, go ahead and type it in there and we'll make sure that we have a chance to answer all those questions at the conclusion of the webinar. Also, at the conclusion of the webinar, you should have a quick survey that pops up right whenever you close out of the application. We encourage everyone to fill out this survey if possible so we can continue to provide relevant content at all of our presentations. And just to let you know, Ms. Donahue has a follow-up webinar occurring on Tuesday, May 13th, titled Do This, Not That, a survey of multiple choice question types, most of which should be avoided. If you're interested in more details or would like to register for this presentation, please visit learn.examsoft.com and click on the Resources tab. And as a last note, today's webinar is being recorded and all attendees and registrants will receive a follow-up email with the link to the recording within about the next 48 hours or so. And I'm hoping maybe within even the next 12 hours. I've been pretty good about getting those out as soon as possible lately, so I'm going to try to keep that momentum going. So once you get that link with the recording in it, please feel free to share it among your peers as you would like, or to watch it over yourself again. All right, with that said, I'm going to turn things over to Ms. Donahue here. Thank you so much for attending, everybody. Please enjoy the webinar, and Ms. Donahue, take it away, and good luck.
Thank you, Carter. It's my pleasure to be here and welcome everyone. We're talking about writing high-quality multiple choice questions, specifically for legal educators, finding ideas, framing them, and editing your questions for plausibility. Carter already introduced me a little bit about my company, BarCrowd. We are assessment specialists that work with legal educators in curriculum design. We've done a lot of learning outcomes and assessment planning and multiple choice writing seminars, similar to what you're seeing here today, but we can work directly with you in editing your questions and doing workshops where groups actually sit down and work together to write questions. We are also developing some software that will allow students, practitioners, and law professors to work together to crowdsource multiple choice questions by writing and reviewing each other's work as a learning tool for formative use in law schools. If you have any interest in any of these things, my contact information will be at the end of the presentation, and please feel free to get in touch with me. When we think about formative testing in the legal field, I think what we'd come up with, most people would come up with something along these lines. In order to test a student's proficiency with some particular content, for example, battery, you would expect the student to be able to do a number of things sort of roughly in this order. You would expect them to know something about that content, for example, the elements of battery. You would expect them to have some kind of skill with legal reasoning, being able to issue spot, being able to reason by analogy, and some of that legal reasoning may be taught in a torts class. Some of that legal reasoning may come from other courses. But then you'd be able to you'd expect the student to be able to put that knowledge together with reasoning to apply the knowledge to familiar simple scenarios, things that you have gone over in class directly. And then ultimately, as the student's learning evolves, you'd expect them to be able to apply their knowledge and reasoning to more remote or complex scenarios in more summative-like assessments. So just to focus us on what today's webinar is all about, I'm focusing today on those last two items, applying knowledge and reasoning to familiar simple scenarios or to remote more complex scenarios as your students' learning evolves. The drafting process for multiple choice questions, as I see it, goes something like this. It's very heavily dependent on editing. You have some kind of content idea that you generate when you're thinking about writing a question, and then you go through a series of drafts. In your first draft, you should be focused on framing your content idea with a learning outcome that you've already established for the class. And for those of you who weren't with us for our first webinar, I discussed a bit about learning outcomes and how it's really important to define exactly what you want your students to know and be able to do when they have taken your class, not just to put together a list of topics to be covered or content areas, but to actually define and share with your students what you think they should be able to do with that knowledge that they're learning in your class by the end of the course. So in your first draft of writing a question, you're framing your content to that learning outcome. In your second draft, you should be reviewing and editing, and this may become wrapped into that first draft as you get better at drafting multiple choice questions, but you should be familiar with best practices in writing test questions and make sure that your question conforms to those best practices. And then in your third draft, you can look at revising specifically with an eye towards the appropriate level of difficulty for the students in the content area and the learning outcome that you are testing. So starting at the beginning with generating a content idea, how do you find ideas? And this is actually, I think, kind of fun and kind of simple once you get the hang of it for law professors in particular, because I think when you start testing the more familiar applications of law, you can easily generate ideas from cases your students have read, and from Socratic dialogues or other kinds of discussions that you've engaged in during class. And you can imagine, for instance, in a particular case, your answer choices, your A, B, C, D choices that you give to students in a multiple choice question could easily be framed as the reasoning of a majority opinion, the reasoning in a concurring opinion, the dissenting opinion, and maybe some other lower court opinion or policy argument or some such argument that was made either in an opinion or in a class discussion. I think that law in particular really lends itself well to the multiple choice format. And by the way, when I say A, B, C, D, I think traditionally there are 4 and 5 option multiple choice questions, but really the number of options is only dependent on how many plausible choices you can think of to give your students, and it's perfectly acceptable to only have 3 options. So a little bit more about that Socratic method. I put together a dialogue that some of you may find a little bit familiar as the hairy hand case, like Professor Kingsfield used in that opening class in the paper chase. You can imagine a professor asking, first of all, what are the facts of the case? And the student's going to summarize the case for the professor, and you can see on the right-hand side how that might translate into a fact pattern in a multiple choice question. The professor moves on and asks the student for, okay, so you've told me the facts of the case. What was the issue that the court had to decide? And that, on the right-hand side, under the facts of the question, the issue generally can be translated into the call of the question here. So for instance, in that hairy hand case, the court had to decide how to calculate damages. And on the right-hand side, my question there at the bottom, what measure of damages is the patient likely to recover? You know, all of this sort of translates through from the Socratic method. And then you get your options as you start talking about the court's reasoning. The professor might ask, so what was the ruling? The student responds, plaintiff was entitled to expectancy damages plus incidental losses. And there my A is, my option A on the right-hand side sort of reflects that, the difference between a perfect hand and a hairy hand, right? And the professor might ask, how did this opinion differ from the damages awarded at trial? And that would flow through to my option B, which in that case, it was the difference between a perfect hand and a hairy hand plus damages for pain and suffering, right? And brainstorming what you might have for options C and D, you'd have something potentially related to what would the plaintiff have recovered had he brought a cause of action in tort rather than in contract law. And option C reflects that, the difference between a scarred hand and a hairy hand, right? And how do you think this ruling affects the practice of surgery? Well, it might make surgeons reluctant to perform risky procedures, and you can imagine an option response there, as I did in option D, that would play on some sympathy that a student might have for the surgeon, that it might make sense for the loss to only be recoverable for what was foreseeable to the surgeon in the course of similar surgeries. So that's just sort of my little Kingsfield in action, how to frame what you're already potentially doing in your classes with students and the kinds of dialogues that you're having into multiple choice questions that would flow sort of directly from what you're talking about in class and be that sort of first level of application in formative testing. So you're not yet getting to remote type questions that are more summative, but you're making sure that everybody's following along in your class and they know what you're talking about and they can do some simple application similar to what you've already done with them in class. Now, this will only work though, of course, if your discussions do flow through to have some sort of real answers about what is the correct answer in the controlling current case law. If you're having discussions in class where it's sort of everybody voicing opinions and no opinions are correct or incorrect, this might be harder for you to frame a question that you would expect your students to be able to answer. That's not to say that all questions that you might write have a winner and a loser or a clear yes or no answer. You could certainly have questions framing, you know, what is the dispositive issue here, and things of that nature, where, you know, if there's no right answer that you've taught your students, then, you know, it's going to be hard for them to select a right answer on a test. So more sources of ideas when you're talking more, moving beyond the stuff that you've covered in class and the material that you expect your students to master as their learning emerges in a deeper way. You move through into more remote or complex applications of law, and there you're going to want to move beyond what you've done directly in class into other kinds of cases like articles and current events, cases that you know that have not been covered in class, although you should be careful that if you're presenting in a test question facts that are really, really similar to a case, you don't want to maybe advantage some students who have seen that case when the other students have not seen that case and are not familiar with the case. So unless part of your class has been to encourage students to read widely, and then you're going to sample some of the readings that you think they should have had, you probably want to take cases that are remote and tweak them enough so that you're not giving any student in your class an advantage over others. Obviously, life experiences, and here's my little tip of the day: when all else fails, start with a man walked into a bar, because between me and you, almost everything that you could test in law, you could figure out a fact scenario where a man walks into a bar, sort of like the beginning of a joke. So now that you've got some kind of idea for how to frame your question, you've got a content idea, you're going to have to push that into a draft that frames the content with a learning outcome. And really what we're talking about here is going beyond content. And test questions, and I think particularly multiple choice questions, are more than just testing content. The ideas that you have for a question are going to be generally content-based ideas. You think of a good idea, you read a newspaper article and think, wow, that's a great example of something that I covered in class, and it'd be a great source for a test question. But a high-quality multiple choice question is going to be a deliberate, focused combination of that content with a learning outcome, which is, again, what you expect your students to be able to do with the content. There's an old saying for writers, murder your darlings. And this applies to multiple choice writing as well. And the point of the saying is, if you've written something that you think is, the paragraph that is most clever, most insightful, most symbolic, most deep, the best thing that you've written in your whole novel, that's probably the paragraph that you should strike. Often these things that we think are very, very clever actually are kind of diversions from the main point of our writing, and that is true in test question writing as well. If you have a content-based idea, it must be framed with discipline to align with a learning outcome, and if it can't be, then it's probably a diversion from the real point of your class, which is what you've already decided is most important through documenting your learning outcomes. A little bit of vocabulary here before we go into the framing of a content idea to learning outcome. Multiple choice questions generally will have some paragraph of facts. This is also called a vignette. It is sometimes called the stem of the question, or a scenario or a fact pattern. Note that if your question is testing for knowledge only, it might not have a facts section. It might just be a question, such as, what are the elements of battery? These might be appropriate in very early learning, just to make sure that people are sort of on board with you before you move into application, but I would use them very sparingly because you really are testing memorization there. The next part of the question is the prompt, which is also called the call of the question, the lead-in. And note that some testing groups also will call the prompt the stem rather than the fact pattern the stem. Both usages I've run into with different testing groups. So I think it's confusing, and I don't use the word stem. The options are your answer choices, which are obviously your possible responses that the students have to choose from. The correct option is called the key. The incorrect options are called the distractors. They distract students from the key. So here's how I recommend that people frame test questions. You start with your learning outcome. In this case, I have a learning outcome that says, I want my students to be able to apply the prima facie elements of basic torts in a variety of fact patterns. Then you fill in your content area. And of course, this learning outcome might flow through many content areas. You'd have battery, you'd have assault, you'd have negligence, etc. So anything that you consider a basic tort, you have this learning outcome. on a page with with different content areas. So in this case, we're going to write a question on battery. The next thing you do is write your prompt, and you can do your prompts before you have any content ideas or have any idea how, what you're going to write for individual questions. And here, the point is that your prompt should directly flow from your learning outcome. It should be basically a response to the learning outcome. If you want students to apply the prima facie elements, how would you test that? Well, you're probably going to ask something along the lines of, does someone in the facts have a cause of action for battery in this case, or for negligence in another case? Having a cause of action would show that a student could apply the prima facie elements. You might think of other kinds of prompts, but this one is certainly, you can imagine if a student answered a question correctly that had a fact pattern based on battery, and the prompt was, does someone have a cause of action for battery? If they answered that correctly, that would give you evidence that they had achieved the learning outcome of applying the prima facie elements. Now from there, once you have your prompt, I have two approaches that I counsel, and this is approach number one, which is you ask yourself, okay, so how might this prompt arise in the real world? And you fill in a fact pattern. And here I used my classic example. A man walked into a bar, and and then whatever happened, something unfortunate that leads to some possibility of a battery action. This is your content idea here. So you had an idea based on a case or based on a newspaper article or whatever. This is the fact pattern that your content comes in. And again, this is the approach number one. You've got a prompt, and then you go backwards to fill in your facts. Approach number two would be, you've got a prompt, and before you go back to that content idea, you list a bunch of options that respond to the prompt, and in the context of your content area, which is battery. And you want your responses to be parallel, and that you want them to flow from the prompt. This approach, I'll show you when it works. It works really poorly when your prompt is setting up a yes or no response pattern. So our prompt here, does a person in the facts have a cause of action for battery? Your answers are going to say yes, they do, or no, they don't, because for whatever reason. And this is very difficult to fill in yes or no answer choices when you don't have facts. You can see I kind of attempted it, but there's really no way to do it well. So when the prompt is framed to require a yes/no response, I strongly recommend you start by writing facts first, and the option choices really don't flow through until you have your facts. However, when you have learning outcomes and prompts that have avoided the yes/no framing of the option choices, I actually prefer the second approach, where you have your learning outcome and your prompt, and then you start writing option choices. And you can often write long lists of option choices simply by knowing the content area and the prompt. So for instance, if we had a different learning outcome here, and the outcome is assess the strength of different legal arguments in a variety of basic tort law fact patterns, that learning outcome, you could easily see a prompt saying, well, what is the defendant's or the plaintiff's strongest argument? And from that, with your content knowledge of the area of battery, you can probably fill out lots of different option choices that would be an argument that a defendant might make in a battery case. He didn't intend to harm the plaintiff. He didn't intend to touch the plaintiff. It was only his umbrella or his cane or some other thing that touched the plaintiff. He didn't touch the plaintiff directly, right? The plaintiff didn't suffer an injury. the contact was consensual because it was in a crowded public place. These are all things that you would think a defendant might argue in a battery action. So when the prompt isn't framed to require that yes/no response, I recommend that people start with writing long option lists, and then you can imagine writing several different fact patterns quite easily from having the prompt and option list already there. Here's another example of that. Different learning outcome. Assess the strength of different causes of action in a variety of fact patterns. And your prompt would be, what is the strongest cause of action? And then you can list all these different causes of action. And those lists, though, can be used with different fact patterns to generate a number of different questions. But what you'll probably do is, for each fact pattern, as you develop the facts, you'll drop some of these options for that particular question because some of the options won't be plausible, right? So you might have this long list of options kind of as a frame, but then as you start writing your individual questions with your facts, maybe you'll have 3 or 4 of these options here represented in each individual question. So moving away from, we've got a content idea, and we did a first draft, which is framing that idea specifically to or with a learning outcome. Next, you should be familiar with some of the best practices in multiple choice writing, which in some cases are maybe a little different than what you may be used to in essay writing. The facts section. Generally, we want the facts section to present a situation that you would expect to arise in the beginning practice of law for attorneys in the relevant field. And you want your facts to be clear, concise, and frankly, just as boring as possible. The facts should not be long, complex, or sophisticated. And by the way, I don't mean to suggest that you dumb down multiple choice questions. The keyword there, and you'll see it throughout these best practices, is the keyword is unnecessarily. Certainly, law is hard, and to ask a question, you often need to use sophisticated language or some amount of complexity in your facts section of your question. But if those facts are unnecessarily long, remember one of the strong advantages of multiple choice questions in testing is you can present a student with a huge number of different scenarios in the same amount of testing time that it would take them to write out a constructed response answer or to speak a constructed response answer, because they don't have to worry about formulating and organizing and then writing or speaking their thought process. They're selecting from a list of options that you've provided. So you can move through a number of scenarios very, very quickly, generally something along the lines of 2-3 minutes a question. So if your facts are unnecessarily long, then you're losing that advantage of multiple choice question testing. Your facts should also not be arresting, salacious, or inflammatory. And again, maybe I should have used the word unnecessarily. Obviously, the law does deal with some unpleasant situations. But my rule of thumb is, imagine yourself trapped on an airplane in a small amount of space with a complete stranger sitting next to you and talking to you. If you're the person talking, and you would feel really awkward reading a facts section of a multiple choice question to that stranger who's trapped with you on the jet, it's probably unnecessarily arresting, salacious, or inflammatory. And humor, unnecessary gore or violence, these things can be distracting to students when they test. I'll leave it at that. You don't want your facts to contain red herrings or additional actors that, again, are unnecessary to test your point of law. And a small exception to that is if your learning outcome is related to issue spotting, so you want students to be able to separate what's relevant from what's not relevant, then obviously that requires you to have some red herrings that are not really relevant in your facts. But again, you want those to be limited to what is plausibly tied to your option choices. So if you have lots of red herring issues or additional actors in your scenario that are never then tied into any option choice, those you can cut. So you want your, and then finally you want to describe the actors in your question not with proper nouns, and that's really hard for a lot of question writers. Rather than use, attorney with a capital A, Alpha, Abe, Betty, rather than use names like that, or in the case of a company, Widgets Inc. or whatnot, it generally helps students to have a functional noun there describing the actor's role in the question. So the attorney, the client, a plaintiff, a defendant, a seller, a buyer, a homeowner, a contractor, etc. Those kinds of just plain old functional nouns help a student track through the facts and the options and keep in mind exactly what the actor is doing and why they're in the question to begin with. A couple guidelines for the prompt. It should be presented as a focused question with a question mark. It should be directly tied to a learning outcome, and it should be answerable even if you didn't have any options to give the students, any answer options. So if you took your facts and your prompt alone, the student should be able to respond to that prompt in some kind of short answer way. Notice the slide here. The prompt should : and then some list. You've probably seen a lot of multiple choice questions written in a similar way, where the prompt is really actually sort of a part of a sentence, and each of the answer selections are a different completion of the sentence. And we really prefer to avoid that setup and to have a focused question, including a question mark, a full sentence there for the prompt, because it's hard to tie an incomplete couple of words to a learning outcome. So, for instance, if your students know that they're going to be expected to apply the prima facie elements of different torts to various learning scenario, to various fact patterns, that's something that they can understand as a requirement of something that they'll probably be doing as lawyers. The reason that they should be able to do that is because that's something that you view as important to the practice of law. It's hard to argue that completing sentences in some way that is applicable to some set of facts that you've given is sort of directly tied to the practice of law. I mean, it's a way to make sure, as a check on yourself too, as you're writing these questions, that you're testing important content, that you expect your students not only to know that content, but you're testing what you think is important for them to be able to do with that content. And if you're not phrasing your prompts as focused questions, it's very easy to get away from that model. Your options should be, this is probably obvious, but they should be directly responsive to the prompt as answers, and they should be similarly constructed, or in other words, parallel. And there are exceptions to the parallel requirement. Obviously, if options sort of are logically meant to build upon one another, then some of them may be simple options, some of them may be compounds. So For example, if you had a real property question having to do with fixtures, you could imagine option choices that stated the rug only as option A, and option B would be the rug and the chandelier, or something along those lines. And you could see where the options would build and become sort of longer lists as you went down the options. So sometimes they're not strictly parallel, but they have some kind of logical order to them when they're not parallel. Your options should not overlap with one another or contain any cues, and we'll talk a little bit more about that as we move forward into part 4 of this presentation. Your options should not contain new facts or conditions that qualify the response to the prompt. An example of that: is the defendant guilty? And one of your options might say yes, if something else is true that you didn't explain in the facts, and it's really qualifying that yes response to the prompt, right? It's saying yes, but only if this other thing is true. And that should not be confused. Not, you know, the word if or unless can be used in options. It's not always bad. When your prompt is calling for a legal test or standard, something along those lines, then your options may be very appropriately incorporating if statements. An example is, what standard should the judge apply to rule on the statement's admissibility? A, the statement is admissible if it is relevant non-hearsay. So you note there, the if is not qualifying the response in any way. It's still a full response and a direct response to that prompt. You could imagine if that prompt said, is the statement admissible? And the answer option was, the statement is admissible if it is relevant non-hearsay. Now we're getting into a problem, because now we're qualifying the response. So generally you want to avoid conditioning or qualifying your responses on something new that doesn't apply to the other options and was not explained in the facts. When you're thinking about best practices and you break down all these different sort of fine-tuned guidance that I gave you on the different parts of the question, please also bear in mind that the high-level stuff here that's really important to make sure your question tests an important legal issue that you would expect a new attorney to be able to handle, and that the question approaches the legal issue in a straightforward manner designed to use the least amount of testing time reasonably necessary. In your third draft, you're going to do kind of a reality check on the difficulty and plausibility of your different answer choices and of the question as a whole. There are all kinds of difficulty you can find in test questions. Some difficulty is good difficulty. It's relevant to whether the students know it and how versatile they are in applying their knowledge. You can imagine very, very difficult questions that are absolutely relevant and useful to you in ranking your students at the top end if it's very difficult. But there are sources of irrelevant difficulty in questions that really doesn't help you to establish what your students know or are able to do with their knowledge. Some kinds of irrelevant difficulty. The facts are, again, long or unnecessarily complex. That adds irrelevant difficulty to the question. The prompt isn't focused, it's ambiguous. The students aren't sure what you're asking. It's sort of like, guess what the professor has in mind. Or the options require students to make unnecessarily fine legal distinctions. So distinctions that you might expect a fellow law professor who specializes in your field to be able to make, but you wouldn't expect a beginning attorney to make. That's probably irrelevant to what you're trying to test in your classes, because you're testing law students who are not experts. Sources of relevant difficulty. Each option is plausible to at least some students. Again, there's no need for 4 or 5 options. If you can't think of anything plausible, don't throw in something just silly or laughable. Use the options that are plausible. If each option is plausible, the more options that are there, that's great, and that can be a great source of difficulty. You want options that track to the facts, so they're plausible in that way, internally consistent with the facts, and you want options that represent a common student misconception, so that some number of students, again, not professors at your level, but that some level of students will fall into the trap of this misconception and fall for this distractor, this wrong answer choice. Each answer option should stand alone without any overlaps with other options. Sometimes overlaps create more difficulty, and sometimes they make the question easier without relevance. So because they're cueing, basically, if overlaps cue a student that, since I know both of these there's so much overlap here that I have to discard both of these options, but they're not doing it for the reason that they're applying the law, right? They're just being cued by an overlap. And there are other kinds of cues that test-wise students can pick up on in a multiple choice question based on the answer options. And those lead to irrelevant adjustments to the difficulty level of your question, because the difficulty is not based on what the students know or are able to do with the content. The difficulty is based on some cue in the language that you're using. So I'll walk you through, this is sort of the right way to adjust the difficulty level in a question. You want your options more or less plausible depending on how difficult you want the question, where you think your students are at in their learning. If you imagine a question that says, what issue is likely to be dispositive in the plaintiff's battery action? And in this case, you've got 2 answer choices here that I've given you. A, whether the defendant intended to hit the plaintiff. And let's just, for the sake of argument, say that's the correct answer based on a fact pattern that isn't here, but that is the correct answer. And one of your alternate options, one of your incorrect answers, states whether the defendant intended to harm the plaintiff. Rather than intended to hit the plaintiff, now we're talking about intent to harm. And that's kind of a mid-level difficulty. Now, and by the way, I'm not a substantive expert here, so all of the professors on this call, I am sure, can come up with better examples of this, but this is just my way of sort of demonstrating adjusting difficulty. You can imagine an alternate B that says whether the defendant intended to cause the actual harm, such as a broken nose, that the plaintiff suffered. Now, I think this option it's still wrong, but it's easier to eliminate as wrong because it's more extreme than the option B above. The next alternate that you could imagine is whether the defendant intended the act of putting on his coat and knew or should have known that he would hit the plaintiff by doing so. That again is a wrong answer as compared to A, but you can see that it's getting a little closer to the right answer, so it may be more plausible, maybe harder to eliminate as the wrong choice. This is the way that you should play with the difficulty of questions. A classic example of adjusting plausibility or adjusting difficulty through plausibility is you can think of a question that says, what is the biggest city? A, Chicago, B, New York, C, LA, D, Boston, right? And you can imagine adjusting the difficulty by making those options more or less plausible. You can make it much easier if you say, what is the biggest city? A, Chicago, B, Topeka, C, Madison, right? I mean, that's obviously a much easier question. So that's the right way to adjust difficulty. Plausibility problems that we get into. One example, and when the option isn't, when the option does not track back to the facts that you've given. Here's an example. In your facts, you say, a drunk man leaving a bar accidentally struck and injured a woman. And then in your question, in your question options, one of your options says, yes, because voluntary drunkenness is not a defense. But that doesn't really track back to the facts, right? Because we never said he was voluntarily drunk. So you probably want to move back to those facts and insert some statement about he was drinking socially at the bar, whatever, to make sure that it tracks to voluntary drunkenness. This is something that if you had a question like this, a test-wise student could look at A and immediately discount it without thinking through whether the voluntariness or involuntariness of the man's inebriation has anything to do with the legal issue, right? They just know it doesn't track to the facts, so it can't be correct. Another example of plausibility problem. Here's some options that factually contradict each other. So students are going to know that, certainly they're going to know that one of them is wrong just through logic, right? The question is the man liable for battery? And we have two options. A, yes, because he intended to punch the woman. B, no, because he didn't intend to punch the woman. Well, which is it? You're the one that's supposed to be giving the facts, and clearly one of these can't be correct. So, I mean, that's kind of an extreme case, but if one of these isn't easily eliminated by referencing the facts, then a test-wise student is going to know that both have to be wrong because they don't have enough facts, they don't have enough information from you to say that either one is correct. Another example, logical overlaps that impact difficulty in an irrelevant manner because students are guessing what the professor intended, or they're simply eliminating anything that's overlapping without doing the legal analysis. In this case, the example is the man liable for battery? A, yes, because he intended to punch the woman. B, yes, because he intended to harm the woman by punching her. Now, with respect to that prompt, is the man liable? If A is true, then B would also be true. It's an even more extreme example, right? And probably, and often what happens is what the professor really is trying to get at is sort of what's the test for battery, and is it whether he intended to punch or whether he intended to harm? But because the question is he liable for battery? You can imagine students getting tangled up here and trying to guess, like, what are you really asking me? Because they're seeing that overlap. Another example, when the options aren't plausible, the options are not plausible if they rely on doctrines outside the subject area domain of your test, that's probably obvious. If you're a torts professor and you ask, is the man liable for battery? And one of your options here, option B, says no, because he didn't form the necessary mens rea, right? I mean, often you can borrow from other subject areas. That's a great source of distractors, actually. But when you do so, you want to make sure that you cloak it in terms that don't cue students, well, that can't be the right answer because this is a torts exam, not a criminal law exam. In this case, obviously, it'd be very easy to fix by just saying he didn't form the necessary intent, which wouldn't give away to the students that you're reaching outside the torts area. But sometimes you have to be fairly clever in the way that you might borrow a incorrect answer that uses some reasoning from another field that the students may pick up on and go, oh, that really sounds right. But you just want to make sure that you're not cueing them through the vocabulary you're using. Generally, an option isn't plausible if it contains a response to the prompt that is noticeably less complete than other options. And this happens a lot when you're talking about liability or guilt. Often there is a number of factors that need to be met if somebody is liable or guilty. So you can see here, A, yes, because he intended his actions, the contact was non-consensual, and the woman sustained an injury. So it's sort of this complete sentence that addresses each of the elements of battery. That would establish liability. Whereas B is sort of obviously incomplete in some way because it's also a yes answer, but it doesn't address all of these different elements the way that option A did. And by the way, options C and D, if maybe those are no answers, or maybe you only have one no response, that doesn't necessarily have to be exactly as complete as A and B, but when you've got two yes answers and you're addressing liability or guilt, often the students are going to just pick up on the fact that, oh, one of these has all of the elements and the other one I don't even have to think about because it's not complete. So that's a way that they can, again, eliminate an answer choice without actually doing the work to analyze that answer choice. So I kind of walked you through generating a content idea, and then the 3 drafts where you first of all frame your content idea to the learning outcome that you want to test, review for all these best practices in drafting the multiple choice question, and then go back to review the difficulty and the plausibility of your options to make sure that they're all tied up with the facts, that they're not overlapping or cueing students to eliminate difficulty or create irrelevant difficulty. When you're done with your drafts, I think it's really important to have a final check where you review the question for what is the relationship here to the learning outcome? Is it still really clear? Is it still testing the cognitive skill that I intended to test? And then also review the question for its relationship to the content area. Sometimes you kind of stray, so making sure that it's still testing the content area or the topic that you intended to test. And then finally, always a second pair of eyes is a good idea. So if you have somebody that will take a look at it, another professor, it doesn't have to be somebody in your subject area, just to give you a reality check. And of course, I'm also available. I'm happy to take a look at test questions that you've drafted. I'll even do a few for free. So feel free to get in touch with me to ask questions or to share materials with me and just get a quick edit from me. I think that multiple choice writing is can be tricky and can be difficult for people at first if you haven't done it before. But once you get the hang of it, you know, I obviously for the value it gives you in terms of formative testing, I think it's well worth getting through that learning curve. So that's what I have for you today. And Carter, are you still there? Carter?
Yes, right here.
Are you multitasking?
No, I was trying to unmute. I never can remember which element in the GoToWebinar control panel it is to unmute myself. It's not in audio, which is what would make sense. It's actually under attendees. So I went to audio and tried, and then I had to go to attendees. So sorry about that. We do have some questions.
Okay.
Okay, the first question is, would this type of question be allied with a learning outcome that students can remember or memorize cases? And they're talking about the very first question that you mentioned in your presentation, which had to do with the hairy hand.
Mm-hmm.
So would that type of, yeah, so then again, the question is, would this type of question be allied with a learning outcome?
Well, I mean, that depends. Every professor is going to have their own learning outcomes, and hopefully if you are teaching a particular case, then you are going to be teaching it for a reason. It's teaching some content that you want students to know, and then how you frame your question is going to be based on what your learning outcome is. So the question that I gave you there, I'm trying to remember what the prompt was. Maybe I'll just go back to it. It had to do with the damages. What was it? What measure of damages Is the patient likely to recover in a breach of contract action against the surgeon, assuming he establishes a breach? So in that question, that would flow from if you had a learning outcome. For example, you're teaching contracts, and one of your learning outcomes is recognize the measure of damages in a variety of contract breach scenarios. So which measure of damages is going to apply to different kinds of scenarios? This is a question that would flow from that. You could ask all kinds of different questions based on the hairy hand case that might lead to different learning outcomes, but to me that was the most obvious one. That's what the case is about. If you didn't expect as a contracts professor that your students be able to analyze a fact scenario with and figure out what kind of damages measure should be applied, then you're likely, well, you're likely not teaching the hairy hand case, maybe, but you wouldn't ask this question. So all of this is very malleable to exactly what do you want your students to know and be able to do.
Perfect. Okay.
There's Kingsfield again for you.
I love that little explosion. Okay, the next question, and this one is actually a very interesting one that I don't even know that I could think of an answer for, so I would love to hear what you have to say on this. The attendee said, I agree that proper names should be avoided, but was never sure if there was any research basis for this, and it was maybe not just the attendee's opinion. Do you know of any studies on that issue of proper nouns or proper names?
I do not, and that's a great question. What most people end up, the reason most people end up eliminating proper names is actually for more, I guess, political sensitivity reasons, not based on specific research about how the questions perform. So in other words, you don't want an entire exam put together, sometimes even by accident. Say you have 3,000 questions in a question bank and you're selecting 100 questions and to give a test, and just somehow or other by accident those 100 questions all have names that are all Joe and Betty, and never once is there a Mei Ling or Shanice or any names that reflect the diversity of our students, the diversity of our population. So a lot of people feel that there are subtle cues, and this is something that has been studied, I think, in the K-12 area, that when you're subtly cueing through question after question after question, some kind of cultural values that maybe that your students maybe don't share, or they're from a different kind of culture, that they can start losing interest in the test as you move forward. They feel like a failure taking the test, even though they know what to do when answering the question. So in the K-12 area, there's some sensitivity there to sort of these cultural and maybe some amount of political correctness in using those names. It's hard to study an individual, like how would individual questions do with names that are proper names or with functional nouns, because the whole concept of eliminating them is when you have a test full of say you have 100 questions and 3 people in each of those questions, the idea is that it's cumulative, that by the end it's like meeting 300 new people at a party. You can't remember anybody's names anymore, whereas you might remember, oh, so-and-so was married to my coworker, so I remember that he was her husband, but I don't remember what his name was. So it's sort of this cumulative effect, and I'm not sure that anybody's ever studied that in terms of the performance of the questions in higher education situation.